Yeah, we can go live.
Good evening, everyone. This is Mahesh, and I'm honored to be your host on this special occasion on the eve of the World Intellectual Property Day, which is celebrated today. It's a privilege to welcome you all to the Global South Dialogue on the Law and Development 2026, a flagship international academic policy forum under South Asian Summit 2026. This forum brings together distinguished scholars, policymakers, researchers, students across the globe to engage in a meaningful discussion on the evolving role of law and the development, particularly within the global south. At the time when innovation and technology and intellectual property are shaping economics and societies, this prestigious event is organized by the Center for Development of Intellectual Property and Research under Naovina Development of Intellectual Property and Research Foundation in collaboration with the Microsoft Learn and Global Partnership for Education. It's proudly powered by the Community for the Academic Research and Development Foundation, whose continued support makes this platform like this possible. Today, the gathering is not just about dialogues but about building bridges between nations, disciplines, and idea. I would also like to take a moment to acknowledge and express our sincere gratitude to our panelist, Mr. Dipendu Das, whose vision and leadership have been instrumental in bringing this forum to life. With that, I extend a warm welcome to all our participants, speakers, and guests. Let us begin this enriching journey of ideas and collaboration. Thank you.
Okay, we can proceed with the first participant. Okay, before beginning the session, there are a few instructions I'd like to provide to all of you. This technical session per presentation will be of 6 minutes in total, which means there will be 5 minutes for presentation and 1 minute if there is any question and answers would be asked in that particular time frame. So all of you are asked to look into the private chat option where the further communication would be done by the host regarding the time slots and the time left. And now moving ahead with the first participant, host, we can call the first participant. Host, you are muted.
Mr. Venkat Rao, Researcher, Center for WTO Studies.
Okay, first participant is not present. We can move ahead with the next.
Second, Parul Anand, student, FECU.
Hello, hi. I hope I'm audible.
Yes,
Yes,
you
you are
are audible
audible.
and visible. You can start.
Okay, great. I'm so happy to be here. I'm so honored that I get to present my work, and I think it's a very important place that we're discussing this at. Global South, and especially I work a lot on AI, and you cannot have that conversation without Global South and climate justice. And now more conversations around that are emerging, and I think this is one of such pieces. So my work focused on how we could combine the concerns of energy security and climate change in India's AI policy. It came from a very personal sort of an acknowledgement where, if you try to bring up climate concerns of AI in the Indian milieu, there's a lot of resistance. I mean, corporates have resistance because it's quite resource intensive, and the governments have resistance also because everyone's kind of really wanting to develop AI, and now it's becoming a sovereignty concern. So a lot of it is also about framing the issue in a manner that gets attention and actually gets traction. And my paper actually focused on how we could reframe that. Um, I try to place it in the core benefits framework that Indian climate policy already follows, and try to place that problem there. Firstly, I think we should really just get started with the connection between AI, energy, and climate. AI and energy have a bi-directional relationship. AI affects energy, energy affects AI. So how that works out is AI affects energy, as in, I mean, we all are quite aware that data centers are quite compute intensive. So in that way, it puts like a lot of energy demand. However, AI also affects energy in a way that it helps decongest grids. It helps more energy efficiency. You can use AI to actually optimize energy distribution better and prevent losses. So it also has a positive effect on the energy sector overall by these applications, and a negative one by putting extraordinary amounts of pressure on energy sector, especially when you consider India. We already have a fragile energy security because we a lot of it's reliant on thermal and coal, and we are quite import heavy. So that is where it puts like a negative pressure. Then how energy affects AI, because it's a bidirectional thing. Of course, I mean, if India has a strong, robust energy sector, then it does not act as a chokehold to AI's development. It is like a structural choke point that determines at the end how much AI can actually develop and flourish in our nation. And energy, I mean, directly affects climate. Emissions and all of that, even affecting our just transition. So that is like the broader connection between AI, energy, and climate that I wanted to set the scene around. Then now I think I go to more of the main part of the thing paper, which is the connection between energy security and climate change. India again struggles a lot with energy security. We already have like a high dependence on fossil fuels, which is really vulnerable to price and supply shocks. And again, with climate change, we are part of the global south. Historically, we do bear the double burden of facing it and also having to really face it. So we are struggling with energy security and climate change both at the same time. And they have always been pretty important policy issues, and with AI it hits both of the intersections at the same time. Now this is great because now finally we can bring in the conversation around AI's climate impact, because India traditionally has looked at the co-benefits approach. That is, it does not really address climate specifically directly. However, if addressing climate change solves another issue like energy security, India is quite down for that. I mean, you can even see that in India's first national action climate change plan in back in 2008, where also the co-benefit happened to also be energy security. So the balance between energy security and climate change and co-benefits has been the defining feature of India's climate policy. And I think that is the framing we can use to address this challenge of AI's energy impact and the climate impact by bringing into that. Addressing AI's energy impact can also address AI's climate impact, and framing these two things together can help a lot. Now, how can that look like? I mean, a lot of solutions can emerge, but broadly, these are what I offer. Green AI infrastructure, mandating that all large-scale data centers have to source a minimum percentage from renewable energy sources. So that also helps with energy security because we're not completely coal-dependent anymore, not import-dependent, and also helps in just transition and environmental sustainability when we're getting to renewable sources. Then looking at fiscal and regulatory incentives for data centers to co-locate around renewable energy parks. Then we can also look at AI applications for energy. As I mentioned previously, AI can be used to also affect, strengthen energy security. In that sense, we can have these good applications that can come up. And then also, broadly also require institution coordination and governance around this topic because it's quite interdisciplinary. You have to look at both climate part of it and energy security part of it to actually come to a solution. So you would, ideally need high-level working groups on energy policy with digital innovation. US already has that. Other EU also has that. So also, developing integrated regulations and solutions, because this cannot be solved in silos, would really help. And like laying down the pathway for India's AI development, which is both good for energy security and co-benefits approach. Yeah, I think this is one of the ways to look at it, and I really hope that the Indian policy space and the Indian government really picks up on this. Yeah, if anyone has any questions.
Okay, participant, what are your policy analysis? Specifically, what are your countries, what you had referred into?
Ah, so okay, so for For examples, and I mean, looking at like policy pathways that could come up, and examples, like I have looked all around the globe, like Germany, Europe, and everything for specific things. But for specifically the policy architecture, I've only looked at India because I'm looking at the India specific solution. That's why I go really into Indian climate policy and the co-benefits approach, because that is what works here. And elsewhere people are just looking at climate and AI directly. Like EU has an environmental impact act in back in 2024 it came out. US also has some sort of legislations that are coming out, but India is not looking at AI and climate at all. So the only way I could conceptualize it, maybe through the co-benefits approach, we can bring this topic more at the forefront.
Okay, there are two suggestions. There are a number of countries which are working on the intergenerational equity. So, like, it's not only for the present time what we are working and preserving the heritage and also the climate, but also for our future generation. So, the artificial intelligence segment specifically looking on the climate change and the environmental impact. So, for me, what I can suggest you, your paper also should looked into the intergenerational equity policy and the principles, how the artificial intelligence and the big data centers, what resources it is utilizing, and how the resources are being drained. So what are the cost profit analysis out of it, whether a environmental impact assessment are being done. So that's how your paper should come up in a more reformative and also in a suggestive way for the policy reforms. So do consider all these aspects into your research while coming up with the revised submission of the manuscript.
Okay, thank you.
Yeah, thank you. We can move ahead to the next participant.
Thank you, Parul. Next, we have Anushri Verma from Manipal Institute of Technology.
Yes, participant, kindly share your presentation.
Yes. I hope that I'm audible and visible.
You are audible
Yeah.
and visible.
Yes, you can
Okay.
start.
Yeah. Good evening, everyone. My name is Anushri. I'm a first year computer science student at the Manipal Institute of Technology, MIT Manipal. And today I'll be speaking on navigating the relevance of democracy and the rise of unified global south. The 20th century was defined by the expansion of democracy. Right. And the central question of the 21st, as it appears, is whether that expansion can be sustained, and more importantly, by whom. That is precisely what my paper set out to examine. To understand why the global south matters today, we must first be honest about what is happening to democracies in places that claimed to be champions of it. Equality frameworks being dismantled, universal healthcare retreating, civil liberties narrowing. These shifts are not happening at the periphery, they are happening at the very center of the democratic world. Interestingly, Greece, that the civilization that gave humanity the concept of democracy, now ranks below nations it once regarded as underdeveloped. Meanwhile, in Nepal, just last year, young people protested not against democracy but in defense of it. Democratic aspiration has not died, it has moved. And if we follow where it is moving, we arrive at the global south. What we find is not a chaos that is filling a vacuum, it is deliberate, principled construction. The EIU, Economic Intelligence Unit Democracy Index of 2025, shows that while Western democracies stagnate, nations across global south demonstrate a steady democratic progress. The momentum has shifted. The framework that is being built is rooted in mutual respect, non conditionality, and shared interests. And it rests on one profound principle that sovereignty is not a privilege extended by the powerful, but a right belonging to all. And this brings me to the heart at the heart of my paper. The global south is not merely available to lead; it is civilizationally prepared to, because democracy at its core is the capability to hold differences together. And no region has practiced that longer or under greater pressure than the global south. For example, India alone holds more linguistic, cultural, and religious diversity than all of the Europe combined, and has governed that complexity imperfectly but persistently for over 7 decades. The West is visibly struggling with diversity today because its institutions were never genuinely designed to accommodate it. The global South was, that is not a minor distinction, that is the very qualification democracy demands. India's Unified Payment Interface (UPI), built to bring hundreds of millions of unbanked citizens into economic participation, has been voluntarily adopted across Singapore, Bhutan, Sri Lanka, Mauritius, and Qatar because it solved a real shared problem that is very critical to global South. Then the Partners in Population and Development PPD initiative has measurably reduced maternal and child mortality rates through peer exchange between nations that understood each other's realities because they had lived them. This is South South cooperation, grounded not in transaction but in genuine solidarity. Compare this to the North-South, traditional North-South cooperation built on asymmetry. Governance defined by the donor, not the recipient. Beneath all the diplomatic language, the message was the same: we know better than you do. South South cooperation proceeds from the opposite premise: equality of standing, non negotiable sovereignty, partnership defined mutually. In doing so, it delivers something the international order has promised for a century and never achieved: the democratization of international relations itself. But intellectual honesty demands I acknowledge this, that the global south is not a finished democratic project. Authoritarian tendencies do exist within it. Corruption persists. Press freedom and judicial independence remain fragile in several of its nations. Cooperation between states do not automatically produce justice within them. The diversity that is our strength can, without strong institutions, become a fault line. So, when I say that the global south deserves its chance, I say it not naively, but with full awareness of what that chance demands from us. For too long, the conversation about democracy has been a monologue spoken by a few on behalf of many without ever truly consulting the many. The global south is not asking to take over that conversation, it is asking to be finally a part of it, to bring to table what it has always carried: centuries of navigating difference, of governing complexity, of holding together what others assumed could not be held. The global south does not ask to be handed a world, it asks only for a space to build one worth inheriting. Thank you.
Okay, participant, I have very basic question for you. Specifically,
Yeah.
when we looked into the global south, there are 78 countries in total. So out of
Yes.
195 recognized nation as per the UN, in global south
Yes.
itself, we are having 78 countries. So,
Yeah.
but when we looked into the geographical influence of the global south, it is like less than a 10% we are influencing, like as a global south economy or southeastern economy specifically. We are
Yes.
not influencing more than 10%. So, how in the political shift or in the economic shift, how global south should come up as its power, like in order to impact the world in a way, in a better way, because when you look into these countries, they are mostly developing countries, like they are
Yeah.
also underdeveloped countries. So
Yeah.
what are the ideas you can think of as of now, in which these countries can come up in a more strong and a more better way
Yeah,
to
so
represent them?
this
Yes.
central idea of global south, that we have always been perceived as a developing nation or underdeveloped nation that is going to be developed or something like, matlab some like the conversation has always been around this developing nations. We need to move forward from this tag that global south is developing. We need like a cooperative association between all the global south nations that can help each other in economic prosperity and military, education, health. All of these factors are what distinct is what distinct is what differentiates a developing nation from a developed nation, and its influence on the world. So all these nations can come up together to help each other in terms of economic interest and political as well. Matlab, we should in the global south should proceed for a democratic realization, and it should help each other grow from and it should help each other grow, remove the tag of being a developing nation to a developed nation.
Okay, so there are two suggestions for you, specifically in the World Bank, also in IMF. When you look into the majority
Yes,
of the nations which are provided with the loans are not
yes, they,
from the global south. Like for your clarification, they are majorly of countries who are backed by themselves. That's Western countries and the other European worlds. So again, when we looked into the economic prospectus, global south, it's much in a better position as compared to the like European states and the European countries, because they are not loan driven, or that they are not debt driven countries. There are countries who
yes,
have not even taken a debt from any of the IMF or World Bank or any of the economic forums. They are well sustaining, but they are growing very slow. They are having no business outputs. So you can refer those reports and you can come up with the better solutions for these countries. Like, but the country where there are no loans, where there are no debts, so that there can be much better options to come up with a more economic within their economics they can develop such framework. Like when European Union comes together for economic
yeah,
corridor and like developing their own economics, why not global south can do
yeah,
so?
like we can have a common currency that, like,
But it's
which
not
is in
only about,
comparison to dollars.
yes, it's not only about common currency, it is a like
Yeah,
supporting currency or the supporting economic
support,
model. So I
yeah,
will ask you
yes,
to look into this segment in your paper. Okay,
okay, okay, thank you.
we can move ahead with the next part.
Thank you, Anushree. Next, we have Imran Khan and Professor Naseem Ahmed from Faculty of Law, Integral University, Lucknow.
Yes, participant, you are not visible and audible.
Am I audible, sir? Am I visible?
Yes, first at all, your slides are not visible.
Uh, Sir, I'm trying to put it onto the screen. Sir, are the slides visible now?
Yes, you can start with your presentation.
So, good afternoon to the honorable panel and all the participants present here. Uh, I will be presenting my paper on the topic of community-based mediation and legal pluralism, rethinking Darul Qaza and access to justice in India. Sir, just last month on 1st of March, the Honorable Chief Justice of India uh, stated that mediation should not be viewed as the stepson of court of law. It should be viewed as an equal partner. So there is a definite movement towards more non-adversarial conflict resolution in India and South Asia at large. The perennial problem that has plagued the global South has always been access to justice. While the ideal of access to justice has always remained out of reach of most of the disputants, because the formal litigation is quite expensive and it is delayed, and the justice is geographically distant in some of the cases. So the community justice mediation models have been most valuable, historically speaking, in all across the global South, in bringing access to justice to the doorsteps of the disputants. India has long harbored plural legal orders within its ambit. We have harbored several cultural and traditional practices within our legal policy. Uh, if they are constitutionally compliant and are right based orders, if they do not conflict with the legal framework that we already have in place. Just Darul Qaza has been one such avenue historically, which has historically extended justice across the country and South Asia in general. It is a historically rooted institution that has worked towards extending justice to the last man standing in the last line of the society. There is a definite need to rethink the position that Darul Qaza inhabits today, because it is not no longer a court of law. It is no longer a parallel court, but it can act as a complementary ADR forum. It is an informal ADR forum, as has been recognized by the Honorable Supreme Court of India, and there is a definite need to tap into this resource that we already have. The community sentiment is there, the community acceptance is there, and because access to justice not only means the mere availability of justice system, it includes the functional capacity of the disputants to assert their claim and obtain a fair hearing, and actually get their hands on some effective remedies. If all of these three are not present, the institution of justice that we already have in place is just lofty ideals for them. The gap between law and the ability to deliver the justice on the grassroots level is widening in South Asia in general. And the law that we read in the statutory books are just becoming lofty ideals, because the courts are overburdened by cases. The litigation is becoming more and more expensive. The procedure is becoming more intricate towards the disputants, and there is also the element of cultural insensitivity in some cases, where especially in tribal communities, also in denominational groups, there is a definite cultural insensitivity that has been observed. In a heterogeneous society like India, a pluralistic structure is actually a healthy structure that permits the conflict resolution to align more closely with the community values. Because communities continues to rely upon non-state informal structures to absolve their conflicts. Darul Qaza occupies this exact non-adversarial space for Muslim communities, which is perceived accessibility of justice. uh, Contrary to popular opinion, so uh, Darul Qaza is not a derelict institution. It is very much active today and has a wider range than some other ADR forums that we have. Also, there is the question of legal empowerment. The institution itself has extended justice towards many sections of the Indian society that has been remained relatively alien to the formal justice system. Sir, coming to the legal status of Darul Qaza, there is a wide debate going on whether the institution itself is legal or not. Honorable Supreme Court, in the case of Vishwalochan Madan in 2014, specifically held that the Darul Qaza is merely a conciliation and mediation institution that is established for amicable dispute settlement. The Honorable Supreme Court went on to recognize that the institution is an informal justice delivery system, and the Honorable Supreme Court also lauded the objective of establishing such institutions of bringing about amicable dispute settlement between the parties. The Government of India, by way of affidavit, is on record of stating before the Honorable Supreme Court of India that Darul Qaza's institution is a protected fundamental right of the denominational community that the Muslims are under Article 26, Clause B of the Constitution of India. Uh, Sir, Article 26, Clause B gives the denominational fundamental right to certain sections of Indian community to manage their own affairs in matters of religion. The Government of India was on record of stating before the Supreme Court on affidavit that the institution is protected by Article 26 and Article 25 by extension. Also, the case of Madhya Pradesh High Court, Honorable Madhya Pradesh High Court, in the case of Adil versus Union of India, it was stated that the institution is only entitled to enter into negotiation and mediation between the parties to settle the disputes. Beyond it, has no
Participant,
mandate.
go to
So,
your findings and conclusions.
sir, sir, The legal framework already exists for the integration and rehabilitation of the institution within the formal ADR policy. Even in the state of Uttar Pradesh, we have Rule 29 and 34 under the Family Court of 1995 and 2006, framed by the Uttar Pradesh government and Allahabad High Court. CPC also has the idea of Section 89, where the suitable institutions, which has never been defined under the statute. It is not necessarily a formal institution. The word used is suitable institution, may be deemed as lok adalat for the purpose of mediation and conciliation between the parties, for the purpose of judicial settlement. So my conclusion is that I have suggested 5 recommendations. The first one is Darul Qaza should be explicitly recognized as a voluntary mediation forum with institutional safeguards, because it is perfectly legal and it is within the mandate of law for it to function as a voluntary mediation center with absolutely no judicial authority. Any participation in any mediation proceeding before the Darul Qaza should be demonstratively voluntary and should be non-binding. Both the contesting parties should receive notice intimating that they may leave this attempt of amicable settlement at any stage and resort to formal legal proceedings. The government of India also adhered to this policy, because in the Honorable Supreme Court of India, the government was on record of stating that any party can leave any Darul Qaza proceeding and can move any formal court of law at any instance. The third suggestion has been, so the procedure undertaken must be transparent, record keeping must be strict, and written statement terms must be produced for the sake of mediation. Capacity building and training for community mediation should receive training on
Participant, you had
gender
exceeded the time.
Sir?
You had exceeded the time. Kindly wrap up.
I'm going to wrap up. Darul Qaza basically, sir, represents a promise of constitutionally compliant legal pluralism, demonstrating just how community-based mediation can indeed expand access to justice in social settings where formal legal order is slow, expensive, and culturally insensitive. Darul Qaza can indeed be integrated within the formal ADR policy of Indian state, because it does not conflict, it does not come into conflict with any existing law, and the framework already exists for the reimagining and reintegration of the institution within the legal policy. So I'm open to any questions. So.
Okay, participant in the Honorable Supreme Court of India 2014. There is one landmark case of Vishwa Lochan Mohan versus Union of India. In that particular case, if you looked into, the court has specified that it is a religious practice. Undoubtedly, it is protected under Article 25. But as soon as the practice violates any of the fundamental rights, or like goes against any of the fundamental rights, like even if a fatwa or even any such kind of religious instruments comes up against any of the fundamental rights, the institution will be lapsed its recognition. So it's already made very clear under the court of law. Again, there are such also points which you had referred into, that that it's basically a mediation part of thing, which generally it's based on the religious forum, and gives both the parties equal hearing options before proceeding with the further courts and all. So, what, according to you, specifically, current status of this Darul Qaza, and as far as your understanding and your research is concerned, how many countries, like following the civil law, is having this Darul Qaza in their legal statute?
Sir, Darul Qaza is no longer a formal court of law. It is a mediation forum. The access of the legitimacy is based on voluntariness. The institutional framework already exists under our law, as I just discussed under CPC Section 89, and also under the Family Court rules. Sir, the Honorable Supreme Court in the case of Vishwalochhan Madan did not state that the institution itself is illegal or invalid, if unless and until it impounds upon the constitutional guarantees. That is absolutely correct, sir. The sir, what I am suggesting is the rethinking and reimagining of Darul Qaza within the constitutional ambit. It absolutely cannot operate with outside the contours of the constitutional values that we have in place, sir. Sir, the subsequent judgments also, sir, from Madhya Pradesh High Court in 2022, from Delhi High Court in
Okay,
2020, and
participant.
also,
That is well understood. That is well
sir,
understood. I am asking you. See, like
sir,
I'm not even asking you in the common law countries because India is such countries which is following the common law. I'm
sir,
asking you how many countries in the civil law is having darul causa in practice because in when we looked into the common law there are various other alternative things. That's why coming this like every traditional practice or religious practices into the law it's not possible, but civil law, like there are a number of Islamic countries which are following civil law into their customary practices. That's why I'm asking how many countries are following darul causa in the civil law.
sir. I am only aware of the institution of Darul Qaza being functionally operational and legally valid under the British legal system, under the Canadian legal system, and under the South African legal system. So, sir, it is. I'm unaware. I'm not, sir, aware of any civil law jurisdiction that is allowing the functioning of the Darul Qaza. But under the British legal system, the courts of Sheen Beth and Darul Qaza both are absolutely legal. Shin Bet are the the Judeo-Christian courts that are operational. Both of them are only and only applicable
Okay,
for
here
mediation
comes
and conciliation, sir.
major research area to look into. There are
Sir,
Islamic
it is, sir.
states. There are Islamic states which are majorly civil law countries. Why
Sir,
still those states have not implemented Darul Qaza? That's my first question. You should look into in a paper.
sir,
And the common law countries which were referred, they are following this Darul Qaza traditional customary laws. How they are coming up with this scope of mediation and how it is different from the statutory mediation laws. So this you have to address in your paper. Then only your paper can come up with a certain concluding remarks. All right. Thank you
sir.
for your presentation.
Thank you so much, sir. Thank you so much.
Thank you, Imran Khan. Next, we have Purna Vijay from School of Legal Studies, Cochin University of Science and Technology.
Good morning. Sorry, good afternoon. Am I audible and visible?
You are audible and visible.
Okay,
Vijay.
so I'll just start with my presentation. So the topic or my paper is titled Carbon Credit System and Climate Justice, a Critical Analysis. So carbon credit system, as we all know, it is a very, due to the climate change and climate crisis, the world has been coming up and formulating different initiatives and tools to tackle the climate change as that. So carbon credit system is one such instrument that was formulated to tackle the climate change by trying to reduce the greenhouse gases emission. So carbon credit system, it seeks to reduce the carbon gases by assigning tradable units, that is carbon credits, to activities that cut or remove emissions. And theoretically, if you look at this background or the evolution of this particular instrument, you can see it in the studies of works of J.H. Dales and Thomas Crocker. So these people, they were basically against the command and control mechanism instituted by the government or the state in controlling and regulating the environment as such. They instead preferred a tradable pollution right. So they thought that they were of the opinion that giving a tradable pollution right would essentially help in internalizing the negative externalities of a product or a human activity as such. So the origin of carbon credit system can be traced somewhere in their works, and this later on this was institutionalized or legally formulated and incorporated into the Kyoto Protocol, and it was further extended and expanded and brought as a part of Paris Agreement. So under the Paris Agreement, in order to offset, in order to countries are now allowed to trade this carbon credit system in order to offset their emission. So that is, if at all countries fail to if at all a country fail to meet their emission target as such, of if a company or something exceed their given emission ceiling, they can now offset it by buying carbon credits from somebody or from an entity which has an excess of carbon credit assets. So on one hand, we have a concept like carbon credits. On the other hand, we have the concept of climate justice. Through the present environment regime, as we all know, we are not just trying to reduce the emission, we're instead we are pursuing a climate justice system, as in wherein climate justice, as we all know, this is essentially based on the principles of equity, common but differentiated responsibility, polluters pay principle, sustainable development, intergenerational justice, etc. So under the system where we essentially consider the we essentially try to bring in a proportionate or a decent demarcation or a decent division of climate responsibilities. We tend to ensure that we look into the uh, historical emission and make sure that the developing countries and the least developed countries who are not historical emitters do not get overburdened or disproportionately burdened by the climate obligations. So, on one hand, we have this, but then my question or the main area of study is whether the carbon credit system goes against climate justice or whether it will help in ensuring a climate justice. So from what my research, what I have understood is like, of course, the carbon credit system is essentially a potential tool in reducing the greenhouse gas emission. It can bring in fund and it can bring in technology transfer, etc. Uh, but then I don't think it would essentially ensure climate justice as such, because of the following reasons. Because it has, if not done or regulated or operated properly, it has an impact of it has an effect of uh, commoditizing the environment, and it kind of gives you a right to pollute, as in, if I may put it in a mild way, this gives developed countries who are essentially rich, they get to pollute or they get to emit how much of a carbon they want, and they can just offset it by buying it from outside or any country. So, and again, if you look at the current system, is so fragmented. The domestic system that is followed in each country is, there is no uniformity as not there. So this is again with respect to the carbon pricing strategy, with respect to the verification and monitoring process, with respect to the quality of the carbon, there is a huge disparity across states. So this is yet another issue that we face. And again, the developing countries has only they've got only limited. So basically, this process of properly regulating carbon credits is essentially a very expensive process. The MRV monitoring, verification, and reporting thing essentially requires a lot of expertise and money. So the developing countries and the least developed countries often lack those technologies and those
Participant, you can move
expertise.
to the solutions and
Okay.
recommendation.
Okay, so if I may move to the solutions and recommendation, my primary thing would be the international regime as to carbon credits and the carbon pricing mechanism should be strengthened. Some kind of binding obligation should be made. Then we can maybe better than the carbon credit system, other alternatives like uniform carbon tax would be a better method in ensuring climate justice. And again, along with this, we shall ensure there is greater transfer of technology and fund to the underdeveloped countries. And there is also a need for maybe you can use, in order to increase the accountability and transparency the carbon credit system as such, we can bring in any new technological innovations to ensure this. And there is of course a need to harmonize the or bring some kind of uniformity across states with respect to the operationalization and working of carbon credits. So these are some of my recommendations in this regard, sir.
Okay, participant, there are one of the concept called double counting. Are you aware of
Yes,
this?
sir. Yes, I mentioned it, sir. Like I forgot to. There, my yeah, there is risk of double counting is also there.
Okay,
I
so
forgot to
how
spell
how
that.
this double counting should be tackled in the carbon credit market?
Sir, I think bringing there's some AI related or technologies can be those kind of things can somehow help in tackling the carbon double counting issue?
See, double counting, I believe you are not understanding in a proper way. I'm just explaining in just 1 minute. Listen it very
Okay, sir.
carefully.
Okay, sir.
So double counting, it happens when same unit of emission reduction is claimed more than
Mm.
once. For
Yes, yes.
example, a host country counts the reduction towards its national target, and the same reduction it's claimed by another company or
Another
another
country.
country as its
Yes,
carbon credit. So in a
yes,
practical ground, nothing is happening, no reduction is happening, but on paper
mm.
the
It
real
has been
world
counted.
emission is being reduced. So
Yes,
ultimately in a environmental note, it will not affect you and me as a living person on on this earth, because
mm.
on a real world nothing is being changed, no environment impact is being provided, but on a paper everything is fine, even a emission is reducing. So that's what it's happening nowadays in a very common places. There are countries reports, there are government reports, they are all are telling that carbon emission is being reduced, they are complying with the carbon monoxide and the carbon dioxide levels, they are complying with the ozone layers level. But on a
Yes,
real world, on a practical ground, that's nothing, that's only on paper. So this
yes,
is the issue. I believe these particular questions has to be more focused for
yes, sir.
now, and your research should be more focused on this particular aspect. So you should
So, do
research
you
on
think, given this blockchain technology, I think can that bring in some changes, or as
no
a
nothing.
citizen? Okay.
No AI can change it. First, the government policies has to be strict. There should be liability upon the government whenever they comes up with a figure. That's how only the change can happen. When a government is issuing something in the paper and saying that we had reduced a carbon emission by 2%, the liability that on a practical ground, on a practical environment, a 2% is being reduced, they should be accountable for it. If they are not reduced, if they're just reduced in the paper, how an AI should help? So their artificial intelligence or the blockchain, nothing can be done. But a more liability based, more accountable based policy or a framework system, specifically international framework, is much suggestive. But it's a matter of research. There are a number of countries, there are United Nations environmental program working on it. You can look into, so you can look into their reports too. That's all. Yeah.
Okay, sir. Okay.
Thank you, Purna Vijay. Next, we have Deepan Tanisha from KLE College, Bengaluru, to present this presentation.
Hello, good
Yes,
evening. Am I
participant.
audible?
Yes,
You
you
are
are audible.
audible.
You can start.
Okay. Yes. So the paper I'm presenting is Gender Sensitive Justice in reference to indigenous women in India and in Global South. So the core claim of the paper is basically access to justice cannot just be talked in the lens of criminal law alone, but instead it has to also account for structural bias that is there in the society, and especially the labor precarity, because the loss of livelihood and structural marginalization will not give equal access to particularly indigenous women is the core claim of the paper. The method we are using is the doctrinal method, where we are looking into United Nations Declaration on Rights of Indigenous People 2007 and the latest UN resolution that came in 2025 that addresses indigenous women as well, and some other cases, for example in Indonesia or Latin American states where similar issues are cropping up. So if I have to move on to the normative framework, the main framework we have is UN DRIP. Now, basically, this declaration talks both about collective rights and individual rights. self-determination, land rights, and fair procedures for indigenous people in general. Now, this is applicable for everybody internationally. Specifically, Article 40 talks about how there should be a fair and just conflict resolution with regard to indigenous customs. But the issue here is, in the recent level, the access to justice as a formal right is being enforced in a lot of countries, including India. For example, we have Forester Rights Act, we have PESA, and we do see courts also interpreting fair and informed consent of tribal people before taking any decisions that would affect them. But what is not included in all of these formative frameworks is the intersectionality, that how women in particular are getting more marginalized, and though their access to justice is available at a normative level, their labor sensitivity does not allow them to access those justice. So the paper goes on to talk about how most of the time they are involved in unorganized sector of work. For example, be it agricultural work, be it forest gathering, be it domestic work. So in none of these spheres they are accounted in an official level or in an organized manner. So this labor vulnerability does not give them an access to go forward and access justice in legal systems. So gender sensitive justice in general also talks about how we have to ensure that be it police officers, be it the judiciary, or be it the enforcement mechanism, be it anybody who's involved in the entire justice process, they have to know how uh, gender sensitivity works, how crimes are different when we look into the intersectionality of men and women. And even within that, we still have to include this intersectionality when we are looking at indigenous women. If indigenous people are vulnerable groups, indigenous women come in a much more marginalized section, where they are in the crossroads of both being an indigenous person as well as being a woman in a patriarchal society, which reinforces the structural bias. So, like I said, the state power, coloniality, and market precarity is what we are basically trying to talk about in the paper, with structural violence and the justice gap. Other than that, the legal pluralism, if it is basically focused in India, where we are trying to see why indigenous as a term is not adopted by India, rather we would use tribal. And then what is the framework that we are seeing, or what is the judicial interpretations we are seeing when it comes to indigenous women. And then for comparative perspective, if you take countries like Indonesia, we've also been seeing so many cases where arrest, intimidation, and land conflict, it already pushes them into a marginalized category. So there, the access to justice is not on a same par as with that of the others. And the same is there in Latin American states and other countries as well. So the reforms that the paper is trying to propose is recognizing, first of all the agricultural and informal work that these indigenous tribal women do, both in India and as well as in international level. Recognizing that work, that labor equality would help them access justice more than just having laws on a normative or a formal level. And access gendered livelihood impacts on clearances and displacement decisions, because most of the human right cases we've seen in international level, be it African system, be it inter-American system or European system, uh, this land disposition and them losing their livelihood is the core issue that we have been seeing in all the cases. So even within that, women are becoming much more impacted because of this particular gender sensitive access to justice. And the reform is also suggesting again the free, prior, and informed participation of indigenous people, and specifically women in this category. Yeah, that's about the presentation. If you have any questions.
Okay, so participant, like when it looked into the global south of gender sensitivity and the like gender roles, gender
Yes.
representation. So we see that the global south still lags behind in a representation and not a uh, equal basis. So how,
Yes.
according to you, like specifically talking about the labor rights, getting equal wage and uh, equal sharing of all these requisite lifestyle. So how to come up with this specifically these things into the global south?
Yes. So there are a lot of the similar to the proposal. There are a lot of UN reports and CEDA committee report. Even when India has also talked about taking measures and bringing up amendments. For example, after the Orissa Mining Corporation Vedanta Limited case, that is when we've seen free and prior informed consent for indigenous people being recognized by Supreme Court of India. Similarly, these kind of a proposal can also be reflected in the newer amendments that we have. For example, while we are tackling the issue of land disposition in our Forest Rights Act or in PESA, we can also include this particular vulnerable group of indigenous women and recognize them losing their what do I say, economic justice as well, so that they do not become invisible in all of this gender accessibility.
Okay, but like there are also in the indigenous people's community-based rights. When you study in number of
Yes.
communities in South Asia, also in Indian specific communities, there are a number of tribes where the rights of women, specifically, I'm not talking about the northeastern, I'm talking about the southern tribes, where the rights of a woman are being centralized and being subjected to the patriarchal ideology. Like there should be some head of the house, and the head of the house has to be a male, and the head of the house has to be decide what are the things should be done. So, but even in the Hindu law, we are having a joint family system, and in joint family there has to be some karta. So, specifically, when these laws are brought, the karta are always deemed to be a men, and like no women are provided in the position of karta. Even if the karta dies, the subsequent it would be succeeded by the most elder son. So that's how the law is molded. So how, I will ask you to look into this aspect. Like it's not only about the framing of rules into the government, it is about changing the societal style, like how they has been living for centuries and how a shift has to be done into their community itself. There are a number of studies are being done by the CEDO, as you well mentioned, but there are various indigenous lifestyle change which is required to be done while looking into this kind of traditions to be followed. So my suggestion to you would be you should look into those tradition, how this cultural tradition impacts the policy making, because the government cannot make a random rule. They have to follow what are being followed for centuries. So otherwise the people will revolt again. So that's how the policy framework and the recommendations should mold into.
Yes, sir. I'll look into it.
Okay.
Thank you for the suggestions.
Thank you, Deepa and Tanisha. Next, we have Loid Ashra from St. Joseph of College of Engineering.
Hello everyone. I'm audible.
Yes, you are audible and visible. You can start.
I am here to express my idea on justice delay, and we can see there's more cases pending in our justice, mainly in global south. This intervention purpose smart justice, a digital public infrastructure to reduce judicial backlogs and improve access to justice in global south. We can see that there are many pending cases in global south. For example, the most of the pending cases are from India. There are over 55.8 million cases, that is 5.5 crore. In India faces 5.5 crore pending case, causing system delays, eroding trust in courts. My idea is a project where smart justice AI use NLP, which is natural language processor, document summarizes prediction schedule to streamline case flow and reduce time to resolution. As India is losing its GDPA, that is 1.5% to 2% on the spending cases, black clocks disproportionately harm the poor through higher legal cost and lost remedies. We can see that there are many communities, persons, or a person who cannot afford the cost of the pending cases or to run a case. They can use our idea, or they can proceed in their justice. We brought a smart justice AI, which is an idea. It is a digital public infrastructure designed to reduce judicial backlogs by automating routing for workflow, summarize, filling, and prioritize case. A technical methodology. We have used natural language processor for automated summarization, extraction of legal issue, and generation of concise case brief. Human in loop review ensures final decision remain judicial. AI outputs are adversary, not determinate. Regular bias audits, transparent model cards, and strict data governance protect vulnerable litigants and maintain accountability. At conclusion, Smart Justice AI offer a pragmatic pathway to shorten delays, lower legal cost, and enhance access to justice for marginalized group. Thank you. If any question that can be asked.
Okay, when I looked into the justice delayed, there are a number of reasons where a justice can be delayed due to the administrative, due to the executive, and also due to the judicial scrutiny of the particular case. So, what are your perimeter of assessing the justice delayed and how you are figuring out this problem with the solution?
Yeah, in simple, we give a file and it will just prioritize and summarize our problems in justice. It can be used by judiciary, litigants, and common people who faces justice issues.
Okay, all right. We can move ahead with the next participant.
Uh,
Thank you.
Thank you, Lohit. Next, we have Varshini Padmanathan from the Rajalakshmi Engineering College.
Good evening, sir. Am I audible? Am I visible? Is my
Yes,
presentation
audible
visible?
and visible. You can start.
Okay. I will continue with the presentation. I am presenting my paper titled Dead Names and Missing Faces Confronting the Data Integrity Crisis in Technology Driven Welfare Delivery Across the Global South. I examined this across three nations, India, Kenya, and Brazil, using comparative doctrinal methodology. So I have chosen this because nations like India doesn't lack the resources for welfare schemes, but they are actually spent on people who wrongfully consume them. uh, Actually, they end up mostly in the ghost beneficiaries rather than reaching the correct beneficiaries who are in need, like the marginalized people, the tribal people who actually need these resources. That's why I actually chose this topic. So let's move on to the problem. So the problem is that in according to first we will see why the problem actually occurs. In 2017, the uh, um, uh, uh, Indian government actually made Aadhaar linkage mandatory for receiving rations to reduce frauds in public distribution system. But the failure in the biometrics have caused denial to rations, leading to cases such as Santoshi Kumari's and further 2.5 million people in Jharkhand and nearly 33% of household in Rajasthan actually face this lack of uh, giving them ration due to the failure in the biometrics failure. And in Kenya, the uh, due to the lack of proper data protection framework, uh, the court actually intervened and asked the government to proceed, actually propose a National Protection Data Act in 2019, and it also actually excluded the marginalized communities such as Nubian community. Actually, they were excluded from the registration centers physically, and these data that is in the Huduma number, the data, it actually contained the data such as the GPS and DNA of the people, which were actually unnecessary. And in Brazil, the structure is actually different from India and Kenya. It actually has the proper refreshment data system, but the quality of the data actually cascades because there is no proper enforcement by the authority. When we move to the cause, the paper identifies these three as the major causes: the absence of mandatory data refreshment, because the standard living environment of the people actually changes. For example, the income pressure, the family growing big, and the disasters and the migration, the data is actually not updated in the traditional system, but in the system that the paper proposes, this is actually included, so that it can actually find the correct beneficiaries and reduce the amount of ghost beneficiaries. And secondly, the absence of community based verification. The traditional system, PDS, actually the public distribution system, actually relies on the digital system alone, that is the Aadhaar linkage to the the biometrics, so that the even when there is no, even if the beneficiary is not alive, the people the fraud actually occurs and it is not rectified. And the and in case such as Santoshi Kumari's, if the court action, if there was any human involvement, they could have gained the rations. And due to that, we have to have a hybrid system that actually has the human involvement as well as the digital involvement, because the amount of data is huge in a country like India. So there is actually necessity for both the intersection of both the digital and the human in the system. And for Andhra Pradesh actually has the offline community backup, and the village elders actually certify and verify the living status of the beneficiaries, so the fraud rate actually reduces and the exclusion rate also reduces. And there is a need for the government to take the responsibility when the algorithm actually fails. These are the three causes of the problem, and let us see the existing solutions and the gap. India actually has the Article 21 right to life, and it is extended to the provision of food by the Supreme Court in 2013. And it has also proposed the Digital Personal Data Protection Act in 2023, but there is no particular welfare-specific refresh cycle. And similarly, Kenya and Brazil also lacks the proper municipal enforcement and periodic refreshment. This paper proposes the solution, the layered legal verification model. It has three layers. The firstly, it refreshes the data and updates it annually, that is periodically. This mandates that there is an annual cross referencing between the civil death records and migration records, and it also allows the beneficiaries to update the panel when they face the income shocks or disasters or any migrations. Secondly, there is a community verification panel that involves both the village elders and the local government bodies such as the panchayat to verify and certify the living status of the beneficiaries, and also it is they review the beneficiary list under the administrative appeal. Layer 3 actually consists of the court enforceable algorithmic transparency. It mandates that the model which is going to be used for identifying the beneficiaries is actually deployed earlier, and see if the data are actually uh, got correctly, and if there is any error in it, and the annual audit reports are
Participant,
actually
you can
submitted
move to
before
the
the
conclusion. You can move
yes,
to the
sir.
conclusion.
In conclusion, this paper actually sees both the objections and the limitations of the proposed model. It has a proper proposed model, but it also sees the objections and limitations of it, and it also justifies why we are actually going to the human and digital uh, intervened system. uh, Basically, the system actually needs proper architecture more than the enhancing the technology. That is what I am concluding. Thank you.
Okay, participant, what is your observation on the South, global South, specifically with the data protection regime?
Actually, sir, can you repeat it again?
What is your observation in global South with respect to data protection?
In Kenya, there was actually a case where they uh,
I am not
get
referring to Kenya. Are you having any statistical data for the global South with reference to the data protection and what are the legislation the global South is supporting with?
right now. No, sir, I don't have any statistical
So,
data.
like, take this into consideration. Your paper should have this type of statistics. You can refer to United Nations Internet Forums databases for this or the research report, and
Okay,
you
sir.
can look into what are the lacunas in the global South data regime, because we see most of the countries are following still today GDPR, which GDPR was
Okay.
initially made for the European Union, but later on it becomes a global adapted model, like not only enforceability but also to come up with their effect throughout the world. So are
Okay.
there any substituted model which the global South is working on, or the global South is looking behind? So that's why these are the things very crucial for your research purpose.
Okay, sir. I will look it on.
All right,
Thank you, sir. Any other questions?
that's it. Thank you. We can move ahead with the next participant.
Okay, thank you, sir.
Thank you, Varshini. Next, we have Reema Bora from National Law University and Judicial Academy, Assam.
I'm sharing my slides. Whether my PPT is visible?
Yes, ma'am, it's visible.
Okay. Thank you. Myself, Reema Bora. I'm a PhD research scholar of National Law University and Judicial Academy, Assam. Today, I'm going to present my paper on racial discrimination in India, a social legal study with special reference to Constitution of India. So the research objectives are to analyze the concept of race and racism, to examine the prevalence and nature of racial discrimination in contemporary Indian society, to explore the contributing factors and impact of racial discrimination, to evaluate the existing international and national legal framework, including constitutional provisions in addressing racial discrimination in India, to assess the effectiveness of judicial responses to combat racial discrimination in India, to suggest measures for strengthening laws and policies to combat racial discrimination in India. The methodology that I have adopted is doctrinal. Both primary and secondary sources are referred in this paper. The background of this study is India is a nation that is a home to people of different races, caste, as well as descent, ethnicity, and these races creates racism. Racism means when one race thinks superior against another race, and it creates racial discrimination. Racial discrimination means when there is a discrimination in employment opportunities, educations, due to the skin color or due to the facial appearances of the people or due to the ethnicity. It creates racial discrimination. Article 21 of the International Convention on the Elimination of All Forms of Racial Discrimination is the only international convention which defines racial discrimination, as well as the only convention which eliminates racial discriminations. It says that distinction, exclusion, and restrictions or preferences based on race, colors, descent, national or ethnicity origin with the purpose of denying equal rights is said to be racial discrimination. Then Constitution of India stated under Article 14, 15, 16, and 21, 17 of the Fundamental Rights, as well as 41 of the Directive Principles, gives equality to the people and eliminates racial discrimination. Then statement of problem: as race creates racial discriminations, race creates racism, and racism creates racial discrimination. Here, due to the racial discriminations, people are denied cultural, social, political, economic rights, which is very important according to the Constitution of India. Due to this, particularly the northeastern people, the African, the Dalits are facing racial discriminations. They face as verbal abuse, harassment, violence, physical assault. Despite India's commitment to international conventions and having constitutional provisions restricting racial discrimination, still there is the practice of racial discrimination in India. The concept of race, as I have said, race means when the human beings are divided into group, and that group consists of the same skin color, same origin, same descent, it is said to be race. But the race does not depend only on the biological attributes. It also depends on the social construction. Then racism means when one race thinks superior against another race, it is said to be racism, and that racism creates racial discrimination. But this racism denies access to the opportunities and privileges to one race and gives priority to the other race. This is said to be racism. Then racism in India, according to World Values Survey, India is considered to be second most racist country because it creates racial discrimination more in Indian sector, and the northeastern people faces racial discrimination in India as well as in other countries due to their Mongoloid look. They are called with names like Chinki, Chini, Nepali, Chinese. So this is said to be racial discrimination, and they find discrimination in different sectors, in employment, education, etc. Then Africans, due to their black color skin, faces racial discrimination in India as well as outside country in case of job employment. Then Dalits, which are said to be untouchables in India, facing racial discrimination in Rajasthan, Delhi, Uttar Pradesh. And incidents like rape, acid attack, students are not getting admissions. These are some of the incidents Dalits are facing. The meaning of racial discrimination. Racial discrimination, as I have said, is created due to the racism. Racism means one race thinking superior against another race. It creates discrimination in employment opportunities. The causes of racial discriminations are like societal beliefs. As I have said, superiority and inferiority. Then diversity of groups. India is a secular country, so there is diverse races. In that situation, racial discrimination is inevitable. The lack of awareness of racial diversity. If there is a lack of awareness regarding the equality of opportunities among the people, so it is creating racial discrimination due to this racial diversity. Then there is an impact of racial discrimination. It creates prejudice, inequality of criminal justice system, increasing poverty because opportunities are denied to every people. Then discrimination in hiring people. Black people are neglected, white people are hired. Then obstacle in employment opportunities. Then international commitments to eliminate racial discrimination. United Nations Declaration on the Elimination of All Forms of Racial Discrimination 1963 mandates that efforts shall be made to prevent discrimination based on race, color, ethnic origin, especially in the field of civil rights, access to the citizen, education, religion, employment. Then the International Convention on the Elimination of All Forms of Racial Discrimination 1965 mandates that each state party undertakes to amend, rescind, nullify all the legislation, regulations which are giving priority to racial discrimination, and it should not engage in activities which gives priority to racial
This
discrimination.
you can
Rather,
come to your solutions and suggestions.
okay. These are my findings and suggestions. As I've said, racism is created due to race. Race means there is a differences of color, skin, origin, and ethnicity, and it is created racism. And racism is created racial discrimination in different sectors like employment opportunities. Northeastern peoples are facing racism. Africans are facing racial discrimination. Dalits are facing racial discrimination. They are named with different names. Like Northeastern peoples are named with the Chinki, Nepali, and Africans, due to their black color, are not getting opportunities in India as well as outside the country. The provisions of the Constitution of India on racial discriminations is given there, but it is only restricting the state. It is not restricting the private individuals regarding the racial discrimination. It should be some more restrictions for the private individual also, because in India there are many places where people are getting access, so there should not be racial discrimination. These are my suggestions. Enactment of comprehensive legislation to eliminate racial discrimination in India. There is no legislation in India which is eliminating racial discrimination. Only the scheduled caste and scheduled tribe is there, act is there, which is eliminating, but it is only regarding the scheduled caste and scheduled tribe. There are other races or peoples for which X should be there. Then synthesizing the large masses through public awareness program. So there should be some public awareness program which speak about the equality of the people, which will speak that there should be no racial discrimination. Then stringent punishment for practicing racism against various racial groups. There should be some punishment for the practicing of the racism, racial discrimination. Then building respect for racial and ethnic diversity. One should respect other race, because India is a secular country, and we have to live together. So there should be some respect for the other races also. Thank you. I have completed my presentation.
Okay, participant, what are your societal observation? How this kind of racial discrimination can be tackled into?
Uh, am I audible?
Yes, you are audible. My question is how you can tackle this racial discrimination on a societal prospectus. Like law is a different subject matter, but on a
Yes.
societal view, how it can be protected.
So there should be some public awareness campaign or public awareness program that will make people aware that there should be equality of opportunity for everyone, and everyone is equal. And Constitution has mandated that through fundamental rights and directive principles, that everyone is have the equal rights and opportunities to each sectors. And after that, one should also have some knowledge that if racial discrimination is created, then punishment will be given for that conduct. One should have the knowledge regarding this. Then building a respect for racial and ethnic diversity. So there should be some respect for other racial people, because one race is not superior against another race. Every race is equal in India. So there should be some awareness program as well as campaign, and also apart from the act, because only in that act punishment should be there. There should be some regulations, policies created by the government for the punishments for those who participate in racial discrimination.
Okay, see, now there are few suggestions for your paper. For
Yes.
the SC, ST and the other thing, these are the caste discrimination when looked at, it is very different from the racial discrimination. But
Yes.
when the government of India, while making the constitution, even the framework of the constitution, comes up with the protection layer for these lower caste people with atrocity like provisions, like whoever
Yes.
discriminate these people, there would be a charges of atrocity like against those who have been that had done those acts. Now,
Yes.
can such provisions of atrocity be applicable when were to cater up the racially discriminated activities? So that would be the first aspect of research. I'm not asking you question, these are the suggestions of your further research. Now the second thing, in the 80s and 90s we saw in United States there are mass number of movements, specifically the Black Lives Matter movement, and those
Yes.
movements were specifically subjected to the racial discrimination, where the
Mm.
black people were being dominated, and that they had been done forcefully worked, subjuged by the white people.
Yes.
So how the US government has tackled those kind of issues, because now we see the industries, in every industries in the US they had provided some reservations to these black people. Not only reservations, some benefit to these black people. They are tackling up with the equal opportunities for these people. They are tackling up with the number of complaints, how to give them a quick relief, and also to come up with the adjustment of their policies that these things never happen. So what are these things they have done it? Because when we took that look into the democratic setup of US and India, these are the two big democracies in the world, and many similarities are there in the US and the Indian democratic setup when it looked into the inclusivity of the various cultures and customs and traditions of various communities. So I will ask you to give a study of United States, how they tackled up with the Black Lives Matter movement and how they tackle up with this racial remark. And the second thing, in the Indian context, whether atrocity can be applicable, and if so, how the atrocity should be applicable for giving a more refined and a reformative policy recommendation.
Okay. Thank you,
Do
sir.
please. Yeah. All right. Thank you for your presentation.
Thank you.
Next, we have Darshana from CMI University to present the presentation.
Participant, you are not audible and visible.
Hello, hello.
Yes, you are not audible.
Can I?
Yes, you are
I
audible, but you are not visible.
okay. 1 second. Can I visible, sir?
Yes, you are visible. You can start.
Okay. Today I'm going to present my topic on development law and international trade in reforming the global for a institutional growth. Let us understand what is the development law according to trade, international trade. Uh, the using law, in development law and the using law and the policies to promote the economics and the growth, to promote the economic growth and reduce the poverty and ensure the social justice in an developing countries. And in an international trade, what is the reforming the global institution for the inclusive growth, that is the, changing the rules and the organizations like WTO, like World Trade Organizations and International Monetary Funds and World Bank, etc. 1 second.
Go ahead, participant. Don't stop.
Yes, sir. This my PPT is not working, sir.
You can simply go downward and proceed with your slides.
Well,
In the slide bar, you can just move downward in the left slide bar.
Left.
You are taking time, participant.
One second. Is it visible, sir? Hello.
It is
Hello.
not visible yet. It is not visible yet. It is loading. Okay, yes, it is visible now.
Okay, sir. Can I proceed, sir?
Yes.
Okay, sir. My agenda of today's topic is like historical architecture and institutional actors and the special and the digital treatment, differential treatment for this reform path and the conclusion. First is historical architecture of the international trade law. In 1944, the British Code, that is IMF, that is International Monetary Fund, and the World Bank created it to the several not analytical interest. In 1974, the General Agreement on Trade and Traffic of an most favored nations and the national treatments principle formally, neutrally, and structurally unequal to the other nations. In 1964, the United Nation Conference on the Trade and the Development. Uh, sorry, the term that falls against the primary accomodatory exports. 1994, the World Trade Organization, like a general agreement on goods and services trades added to the developing nations in the lack capacity to the excess of their implementation. Second, coming to the institutional actors and the governance gap. Next, in a WTO, the greenhouse exclusively for the developing nations were the impartial for the negotiations. And in appellant body crisis, USA blocking since from 2017. Doha round partially since paralyzed since in the 2008, and litigation lost its limit in on a dispute settlement body access for any least developed countries. IMF is a weightage odds of a USA de facto odds imposed to with discretion social costs, which has been impacted on International Monetary Fund and in the World Trade Bank. The governance controlled by the creditor nationals and structural adjustment adequate by the policy share and conditionally misled with an bruiser priorities and limited accountability to affect the communities. Third one, a special and a differential treatments of an like what is a STD provides. That is, STD provides is um, sorry, ISTD provides a longer transactional period for the obligation and extreme to form the sum of the trade disciplines and generally system of an reference and the technical assistant of the provisions, and 150 plus provisions across the WTO in 2033, and encouraging and not by systematic flows, that is says encouraging and not binding the obligations reactive rather than the transferative, and self discretions of an developing countries as status created and abused. The appellant body jurisprudence has been restrictive and no trade adjustment has assisted in the southern workers. Reforming pathways, pluralisms, that is the IITs and tech class on e-commerce and risk agenda set to the major power of an least developed countries faces to take it or leave it. E-commerce rules may block in or platform the dominant. Human right increase UV, that is European Union, due diligence in the supply of chain. In the case of US scrap dealt environment basis and GSP plus conditions on a 727 convocations, and risk is the discretions and protectionism is purely discreet. And in SS trade, 30% of the global merchandise and American Continental Free Trade Area of an 1.3 billion people of an 90% of traffic removal. The World Bank of 30 million lifted a poverty by the 2035, and BRI investment built the depth and the transparency risk. Coming towards the inclusive legal architecture, first one is democratic WTO governance, replace the greenhouse informality with a transparency and inclusive decision making. And second one, redefine the STDs as a permanent and result through the applicant features to trade and trade the development features. And third one is enforce the sustainability development and the human rights as a binding commitment and not a experimental preamble. Fourth is reforming South to South cooperation and African. Ne- so African continental of trademark with an technical assist and the reform multiple sources. Thank you. Hello.
Okay. Yes. Participant, I have one question for you. You had
Yes.
referred like WTO provisions in number of instances of your slide. So,
Yes.
what according to you the compliance of WTO into the underdeveloping countries? Specifically, when you talked into the global south, there are a number of countries who are least developed. So, in the
Yes.
WTO segment, like there are various compliance mechanism for the developed countries is different, for the developing country is different, and for the underdeveloped countries is different. So what are the compliance the current global south is following up, and whether they are following in a very obedient manner, or they are moving towards something different?
They are doing to the different manner, so like minimizing the traffic's periods um, and other various provisions in an doic round they are bringing up to, sir.
Okay, different in the sense, in which sense you were talking about?
In traffic, so traffic applies is 90 they reduce it to the traffic supplies and important and exporting uh, goods and services of products of developing countries, so.
Participant, your topic requires much more uh, refined research. I will suggest you to research on one of the area which is very pressing area. So when
Yes.
the WTO was made, it is also made with one of the mechanism known as dispute settlement mechanism for
Right,
the
so,
countries, for the member countries, if they had any state interstate or interstate disputes.
yes, sir.
But currently we see the dispute settlement mechanism is completely is on hold, and there
All
are
days, sir.
various countries who are not following those mechanism. And there are the leader countries, superpowers, who are thinking themselves that they are more powerful than the whole WTO member state. That's why they need not to follow those. So
Yes.
what according to you, how this dispute settlement mechanism should be more workable, or they should stop, and they should come up with a new mechanism? So these are the subject matter of research. So your topic caters all those. You should come up with a more reformative research in order to
Okay, sir.
contribute something to the research paternity.
Okay, sir, I will note on it, sir. I'll work on it, sir.
All right. Yeah. Thank you. We
Okay,
can
sir.
move ahead to the
Thank you.
next participant.
Thank you, sir.
Thank you, Darshana. Next, we have Praktik from uh, Oka Tashida University for the presentation.
Sir, am I audible?
Yes, you are audible and visible. You can start.
Good evening, judges. Today I want to explore a critical question in the global energy transition. If lithium powers clean energy, who controls lithium? While lithium ion batteries dominate storage markets, their supply chain is geographically concentrated and environmentally contentious. This creates a paradox: mineral wealth without technological sovereignty. My presentation argues that the global south must move beyond lithium and invest in diversified mineral ecosystems for the next generation supercapacitors. Lithium extraction is heavily concentrated and refining capacity is dominated by a few regions. At the same time, extraction often leads to water depletion, land disposition, and ecological damage, particularly in Latin America's lithium triangle. This creates a structural imbalance. Countries rich in minerals remain dependent on foreign processing and technology. Decarbonization should not mean repeating extractive dependency under green narrative. Now, supercapacitors differ from lithium-ion batteries in three key ways. First, they can last up to 1 million cycles. Second, they charge and discharge almost instantly. Third, they reduce dependence on lithium and cobalt. For emerging economies facing grid instability and urban electrification challenges, supercapacitors enhance resilience and reduce import dependency. Next, we're talking about the alternative mineral pathways. Beyond lithium, we have viable alternatives. Sodium is 1,000 times more abundant and geographical dispersed. Manganese and vanadium oxides are widely available in Africa and Asia. Titanium-based amexines offer high conductivity potential. Biomass derived carbon from agricultural residues can create inclusive green manufacturing pathways. Diversification reduces geopolitical concentration and opens domestic value creation opportunities. Talking about the governance and the industrial strategy, technology alone is insufficient. Existing mineral regimes often replicate colonial extraction models. Reforms must include local processing requirements, enforceable ESG standards, community revenue sharing, mineral justice assessments. Additionally, patent concentration requires exploring technology transfer mechanisms and green patent tools. Green industrial policy, including R&D subsidies and public procurement, can shift countries from raw exporters to technological producers. Talking about the South-South cooperation, rather than competing for Western capital, global South nations can coordinate. BRICS Mineral Innovation Alliances, African CFTA battery value chains, ASEAN clean energy hubs, shared research centers, and pooled procurement reduce dependency and increase negotiation power. This transforms fragmentation into collective leverage. Talking about the economic development implications, diversifying beyond lithium offers supply chain resilience, reduced foreign exchange vulnerability, high skill job creation, and stronger domestic energy ecosystem. Next, here is the policy roadmap which I have devised for 2026 to 2040. To operationalize this shift, governments should establish National Alternative Materials Mission, incentivize biomass to carbon electrode manufacturing, reform mining laws for value addition, create South-South research alliances, link climate finance to mineral diversification, and integrate supercapacitors into grid modernization. This is not a 1 year or 2 year game. It is a long-term strategy, a long-term vision, which need to be embodied by the global South alliances. Then only it can be fulfilled and enforced completely. Talking about the conclusion, the clean energy transition must not reproduce extractive inequities under a green label. By investing in sodium, manganese, titanium, carbon-based and biodevized materials, the global south can reposition itself not merely as a mineral supplier, but as a technological architect. Beyond lithium lies an opportunity to align sovereignty, sustainability, and shared prosperity within a new industrial paradigm. The future of energy storage must not be monopolized. It must be democratized. Thank you.
Okay, participant, your renewable like energy sources or the ores, whatever you have described, what are its authorities or what are its statistical sources?
Sir, are you talking about its sources, means the natural sources from which it is derived?
No, no, no. I'm talking about, have you cited any statistics data on the basis of which you are referring these like alternative for the global south and the other countries?
Sir, there are two types of data I have referred, not statistical data. First, sir, how they are scientifically, first based on their properties, how they can be beneficial in a country, to a
No, no, no.
country's energy production.
I'm asking you simply two things. See, in order
Yes,
to suggest that this type of materials or this type of minerals we can be used alternatively, we have to
yes,
know
sir.
that the regions which you are taking up as a study, those particular regions are having those materials or the minerals in presence in their atmosphere, in their geography. If those countries which you are suggesting are not having those alternative minerals, then how these countries can come up with your studies view? So I'm just asking whether have you done those preliminary research statistical data support of the countries you are referring that they can fit into these. Those countries are having these resources.
Yes, sir. There are some countries like I have cited manganese and sodium. So, taking in account the global south, Indonesia, Malaysia, Myanmar, these countries are having deposits of these alternative energy sources. Then talking about titanium we have in titanium, thorium, and and to some extent lithium also. India, we have reserves which we can utilize and into energy production.
Specifically, like when I looked into the lithium, so the
Yes, sir.
lithium productions of the world is having a lithium triangle, like comprising of Chile, Argentina, and Bolivia. So these countries comprises a lithium triangle, and they are the dominant share of the global lithium reserves. So, meanwhile, like these countries, specifically Indonesia, Philippines, and Brazil, they are having a very concentrated supply of lithium reserves. So, why does this country will require a alternative of lithium when they are having abundance of the resource?
Sir, the answer is very simple, sir. Especially talking about the global south countries or our global Asian countries, many countries are still developing. They are not developed, and their economy. So, one thing is cost efficient. Not only lithium, not only these resources I have cited, they are cost efficient, but they are not only cost efficient, but they are also very useful in terms of energy production, and especially in countries like Indonesia, Philippines, Malaysia, which are still emerging economies. So and which have not a good which have not very developed ties or network of global network regarding
Okay.
energy
Participant, I will
resources.
suggest you. Participant, I will suggest you. Like your study should include a cost profit analysis of lithium and its alternative materials, whatever you are suggesting.
Yes,
The
sir.
per cost of the living standard we are having, light, fans, and all this whatever is required in a daily basis. You will take up a study where a lithium is used as a energy generative resource for for powering those resources in a daily life, and in the other alternatively you are using these materials, whatever you are suggesting, these ores, instead of lithium, and those cost study method should reflect that these particular list of materials which are used in place of lithium, they are coming up as a cost effective, then only your research paper can sustain. So this particular thing has to be included, then only we can look into your paper. Specifically, you are suggesting a region where there is dominant market player of lithium is presence, and in order to come up with your study, in order to support your study that we should think beyond lithium, there should be something prevalent or something in mind that the people or as a researcher us we should looked into. Understood?
Yes, sir.
Okay. Thank you for your presentation.
Thank you, Praktik. Next, we have Subhash Patel, from a professional from Quantus Research and Capital Private Limited, for the presentation.
Participant, you are not audible and visible.
Yes, yes, I'm presenting, sir.
You are not visible, participant. Kindly turn on your camera and unmute yourself.
I've turned on my camera, sir.
It's not visible. Okay, if it is taking time, we can move ahead with the next participant.
Okay. Uh, Next, we have Shubhesh Sawant, a student, for the presentation.
Participant, you are not audible and visible. Suvesh Wawant. Okay, yeah. Subhadra Patil, yeah, she has turned on your camera. I think we can proceed with her itself.
Yeah.
Yes. Yeah, like participant, kindly share your presentation. We'll proceed with you.
I want to share this.
Host, kindly inform the next participant in the chat box to keep their PPT ready.
Sir, is my PPT visible?
Yes, it's visible. You can start with your presentation.
Uh, hello, judges. I'm Shubhra Patil, and I'm presenting on South-South geopolitics and dialogue-centered leadership. How India has a dominant role in this framework, and what is the diaspora of India in this geopolitical instances in the recent era. In reference to the West Asia conflict involving Iran through cooperation, sovereignty, and policy exchange. So, what I looked into this, the geopolitical era and the recent war that is going on between Iran, Israel, and US. India plays a very dominant role in shaping shaping this event. If India remains neutral in this diaspora, then how it impacts the entire geopolitical constitution of peace that we are looking into this direction. So it is beyond development. It is the geopolitical dimension of South-South cooperation. What is the gap? Development partnership dominates discourse, crisis diplomacy, and geopolitical stabilizations are overlooked, and that is the gap. And my argument is like that South-South cooperation is also normative and strategic framework for crisis response and conflict sensitivity policy exchange, which happens between India and a South geopolitical nation. And in this case, the case study of India West Asia posture is an operational expression of South South geopolitical principles for India. There are six principles that bind South South cooperation. One is sovereign equality, non interference, non conditionality, mutual benefit, peaceful coexistence, and strategic autonomy. If we'll look into this diaspora from the First World War to the Second World War, to the this diaspora of today's war era, which we do not term as a Cold War, but which going into that direction. So, what is the India's role in that direction? Specifically, non-interference and non-conditionality are very important structure in this diaspora, and I say why. Because if India will settle in any direction, geographical extreme poles, then it will entirely bind the south geopolitics to go in that direction, and which will be affected for the peace. The same principle that guide development cooperation also furnish in this war era language for responding to conflict, privilege restraint dialogue, and collective stability over militarized alignment. So my suggestion is that rather than having militarized alignment in this era, India should respond through furnished language, which is non-interference and non-conditionality. And why is it so? India's diplomatic tradition and a Panchashil ethic. These are our ethics from the past. 5 principles of peaceful coexistence which matters for diplomacy. This is strategic autonomy of continuity, and it is not at all should be considered as something that India is not playing the dominant role, but India is playing the leading role in this era, and it should not be taken as India's weakness. This is a south-south relevance, and it just not matters for the India. It matters for the entire south-south geopolitical dialogue, and India's position rejects a false binary that is being present in today's Cold War, and not alignment and nor or passivity, but active dialogue without formal entanglement and principal restraint without isolation. This is very important. What is India's official position on the West Asia conflict? That they exercise restraint and avoid escalation, prioritize civilian safety, pursue dialogue and diplomacy, respect sovereignty and territorial integrity. And why this matter? This matter for preserving policy flexibility of entire South geopolitical dialogue in the world politics. Strategic logic, energy, economy, and citizens. These matter for India. This matter for also for our maritime security, and India's navy is playing very dominating role in this diaspora, and maintaining dominance of not just of its nation but entire South geopolitical polity in this war. Dialogue centered leadership, a south-south model. What is this model? That maintain communication within this entire diaspora of geopolitical south, refuse impose alignment, and advise normative language, that is peace, civilian protection, and de-escalation as the basis of international engagement. 4 policy lessons for the global south. Link conflict to development planning. We should not do that. Wars in strategic region affect energy, food, labor, and inflation. Foreign policy crisis must be treated as developmental governance problems. Build a shared jurisprudence of de-escalation, restraint, dialogue, and sovereign respect over a diplomatic template for developing states facing wars whose costs are solicited across the global south. Institutionalized strategic autonomy, that is diversified supply chains, strategic reserves, and whole of government crisis assessment are policy choices and not just slogans that lend themselves to adaptation. Exercise a global governance function. Speaking in the language of sovereignty and development sensitive stability helps developing countries shape international discourse, not merely react to it. So we should not have any reactionary policy, but we should have condensed policy, which will be very cooperative in the next coming 4 to 5 years, and will take this diaspora to next 15 years, given what is happening in the war with Iran. Sovereign equality, non-conditionality, peaceful coexistence, and non-interference, mutual benefit, strategic autonomy are the very core principles of these dialogues. Then conclusion, sovereignty without subordination. Central thesis, India's position on the West Asia conflict reflects a sovereignty without subordination, dialogue without passivity, and neutrality without any silence. We should not keep silence on the topic which are of the sensitivity, because they will widely affect India and its geopolitics, and not just its geopolitics, also about its economy. The way our currency de-escalation and the way our currency is accelerating towards 100, it is so much involved how the India plays roles of geopolitical South blockade in this war. So we should not keep a silence. Where we need to speak, we should speak. Broader significance. South-South cooperation must be expanded beyond development partnership to include crisis diplomacy, resilience-oriented policy exchange, and alternative framework of geopolitical stabilization. India should come as a leadership of a bloc, and India is already has bestowed with lot of governance the leadership role in this domain. That's what we see from the geopolitical observations. Non-generating potentials. India is not merely a reacting to regional conflicts; it is participating in the gradual construction of an alternative that is coming out in this domain in consideration of the war. Thank you.
Okay, participant, when we see it is not the first time like us, we are having such discussion where a South-South cooperation or South-South solidarity should work into. But one of the major problem in geopolitics in the South Asia, specifically the Southwest Asia, are the Iran Gulf tension, where the countries itself are rivals. So
So,
how
you are
this
not audible to me. Can I repeat? Hello, sir.
host, am I audible? Host, am
Hello,
I
sir.
audible?
Yes, sir, you're audible.
So,
Okay.
there was network loss. Can you repeat the last part, sir? Please.
Yes, I'm asking you, when we looked into the geopolitics of the South, it is not for the first time we are discussing the South-South solidarity or South-South cooperation. There are number of conclaves or the gatherings where the South-South cooperation has been discussed. But the real practicality in the global South is the conflict between the South itself. There are rivalry you see in the Iran and the Gulf states are in war. So in South, in the West Asia, we are having this conflict all together. So how this global South can come together, or what are the solutions you can propose? Okay, where we are itself fighting for among ourselves, how we can come together?
As per my observation and of the current geopolitics, there is a lot of pressure on India to to stick to this. And this is a bipolar disorder between Russia and US, and China supporting the Russia on one side, and the US take one side. So my observation is that rather than aligning to any bipolar order, the India is taken through lot of precedents, is taken as a leadership of non-alignment. And whenever India speaks, the dialogue shapes that this is considered as India's less dominant position. But my observation that this is the most dominant position. If we can proceed as a third bipolar of this conflict, and we clearly and dominantly and confidently position ourselves as non-conditional and non-alignment pole of this conflict. So my observation is that India should lead in this domain, and lot of there is a pressure on our currency, and there are currency attacks happening, and there is a lot of pressure on India to leave that South Pole. But if we'll take our entire history and our Sukarno movement, and we will just go through the Panchashil, then this is very important that India holds its position of non-alignment and non-conditionality. So that is my research about in the current Iran, US, and Israel war.
All right. Thank you for your presentation. We can move ahead with the
Thank you.
next part.
Thank you so much.
Thank you, Shivash Patel. Next, we have Shubhai Saval, a student to present there for the presentation.
Good evening, sir. Am I audible?
You're audible.
Let me quickly. Is the screen visible, sir?
It is visible.
So, the topic of my research is urban inflection points in the emerging markets of the global south, because we all are part of the global south region, which is currently experiencing a vast and rapid economic expansion. So what this does is it pushes us towards a transition phase where we arrive at an inflection point from a lower income and a lower standard status to a higher income status. Thing is, some parts of the global south or some parts of countries in the global south are experiencing this transition phase earlier and faster than the others. So when they are going through this transition phase from a lower to a higher income status, it invites a new set of problems with that, which are more or less similar to what you would see in the first world countries, which are more similar to the problems you see in developed or advanced economies. And that is what this research paper delves into and examines. So here we have the constraints created by gentrification and haphazard development and growth. Here we have the case of Goa, which is India's smallest and wealthiest state, and it's currently navigating a critical economic inflection point where it's making this transition, and rising demand from constrained land supply and housing is creating this gentrification process in the state. So first we take a look at what the paper exactly delves into. One is the inflection point. That is, we understand the change in demand for estate and housing assets because emerging markets shift from lower to higher value creation. When that happens, even the demand for the quality of estates and assets changes. People start demanding more costlier estates, more costlier houses. They start demanding more costlier assets as the economy of that region grows. Next, we look at the legal frameworks. We will look at the use of land laws, zoning changes, what legislative action works, what is being done right and wrong, and how it is shaping the change, or how it is, you can say, how it is fueling or helping prevent the gentrification processes, what's working and what's not. Then we look at the vulnerable populations. We will assess the socio-economic and legal impact on migrant and informal sector groups, which are both from local and non-local as well. We will focus on the housing access and displacement. And lastly, we will look at the governance effectiveness. We will see whether existing mechanisms can ensure equitability and sustainable development and access to justice, or whether they are falling apart and falling short somewhere. So, first, we will look at the paper structure and the approach. There are three sections mainly. First is the dynamics of inflection, where we look at the cause and effects of this process and transition on the law and economy. Then we look at how this economy works. What are the symptoms? What are the causes? And what ends up fueling the entire cycle over and over again? And lastly, we will look at the legislative toolkit, which shows you the policy reforms for tech, inclusion, and sustainability, which we can learn from other parts of the world, as well as some of our own solutions, which have been discussed over here, which can be effective in reducing this problem's intensity. So coming to the dynamics of action, this state is India's smallest state and also the wealthiest state in the country by per capita income and HDI. So compared to much of the country, there are higher standards of living and higher incomes, even though it has a very small land area of 3,700 square kilometers. Urbanization is also one of the highest in the country, and population growth is not that high. Further, the laws and planning systems in this state are a little different from the rest of the country. You have something called the Town and Country Planning Act and Comunidades. So these are bodies which are unique to this Goa state only, because the TCP establishes a centralized regional planning system in the state which covers the entire state. Along with that, you also have Comunidad bodies which have a say in land holding and zone changes, because they are the ones who have been collectively holding this land for centuries. So now what's happening is that the state is approaching a full inflection point, and because of that, a simultaneous migration is being triggered, where you have people from higher income brackets as well as migrants from lower income brackets simultaneously migrating and adding an influx into the state. Higher income because they have a desire to participate in that market, driven by a desire to purchase second and third homes and properties. So they want to hold assets in the state. They want to participate in that economy and get a hold of its lifestyle and its resources. At the same time, the lower blue collar migrants are also attracted because they see an opportunity for earning a livelihood. Migrants from poorer parts of the country are driven because they want to earn a higher income, and they also tend to fulfill the demand required for these construction and infrastructural capacities, which is what pulls both migrants from both of these income brackets into the state, and that starts putting pressure on the economy of that region. and it creates an artificially inflated growth which is far more outpaced than what was organically being produced in the first place. Continuing that, we see the land use regulation and the planning gap. So the distortion is that this whole artificially inflated demand, where you have a lot of increased housing demand and a lot of real estate development and purchases happening, this has resulted in a very unproductive land use, and this creates a problem of locked houses in the country. So currently, if you see, Goa has the highest
Participant, you can
proportion.
move to the recommendations and solution.
Sorry.
You can move to the recommendation and solution.
Yes, sir. So, in a global context, we will see how to solve the gentrification problem up to a certain extent. So, this is not a new problem. This has been experienced in other parts of the world as well. If you look at Barcelona, if you look at places like Puerto Rico, these are places in developed countries which experience a similar problem. There's extreme wealth influx and extreme migrant influx, and that puts a pressure on the local economy and participants. So, here we will look at how it can be, to an extent, eased and dismantled. So, firstly, there are solutions like a betterment tax, as per the Henry Tax Review of 2010. What this does is it captures windfall gains from zoning changes and it redirects that value and revenue towards affordable housing. Basically, any kind of zone change which is done from a public decision will also trigger some taxes which take a revenue from that value change. That introduces a progressively compounding vacancy tax on the underutilized properties to discourage speculative second home ownership. So, what happens is people who are artificially pushing the demand up are discouraged to participate, and at the same time, it eases the market pressure to an extent. Second is planning integrity and anti capture. We can introduce cooling off periods for public officials who are in land use decisions to reduce a conflict of interest. It can also help us streamline and digitize the approval processes, as we see in places like New South Wales in Australia. They have used similar solutions to enhance the transparency and reduce corruption incentives. Third, we can do participatory and inclusive planning. Now, this is already present. It can be further polished and improved better by strengthening the role and power of the local bodies. So, in this case, it would be strengthening the role of Comunidades of Goa and local stakeholders, incorporating informed consent principles, and also investing the revenue earned from the taxes and policies into digital land, geospatial mapping, real time zoning databases. These are all solutions which are present in developed nations like Singapore, Netherlands. They use the revenue earned by the state to invest in these kind of infrastructural developments. Lastly, we also use the revenue on human capital reinvestment. When you reinvest into the local population of that region, into their education, technological literacy, and workforce development, it enables them to transition from just stakeholders into active beneficiaries. With their skills, they are able to attract more investment, more you can say recruiters, and more people who are willing to hire them and pay them a good, handsome white collar salary, because now you have a pool of people who can offer you skills from a they can offer you skills which are required in a developed market. This creates a virtual cycle of inclusive growth, as we see in countries like Singapore, their skills future model and their smart nation model. It's the same model which has been working in these small countries, it has helped them become global financial hubs. So the core argument is that whenever growth comes, whenever you have good capital growth and you have high incomes coming into a region, we should not just we should not just watch it grow, but we should also manage it. Because if you allow this kind of growth, or you can say development, to spiral out of the control of the local and the if you allow the local economy to just spiral out of the control of locals, eventually they will not be able to remain healthy participants in their own economy. So this gentrification is not an incidental byproduct of development, it is a legally mediated and also sustained process. The goal of the governance in transitional economies should not be to just try to stop and restrain growth, but to shape it so that it doesn't spin out of control. By deploying responsible land value capture, deploying responsible taxation policies, and strengthened planned oversight, these kind of regions can redirect urban transformation gain toward public investment and public welfare and human resource development as well. So these kind of regions like Goa, and then following us, the global south, other parts of the global south which will be experiencing this growth in the future, they can navigate their inflection by balancing capital
Martin, kindly
expansion with social
conclude.
stability.
Okay. So I have one question for you. In
Yeah.
the global south, in the recent times, as you well mentioned, in many cities, many urban planned cities in India, we see in the name of gratification, like there are also a term called a green gratification, where the town plannings are proposed in the name of completely green environment, green more environment friendly colonies. But the major problem in all these countries, in the South Asian countries, are like informal housing and informal planning. So my first question to you is, can a informal housing system coexist with the modern urban planning framework with respect to the global south, whatever is happening nowadays?
I think this is where we need to come to the part of legislative toolkit, where we need to have strong decision making and strong policy making to sort of address the problem of informal housing. So, as you said, in many Indian cities, there's a huge problem of encroachment and a huge problem of illegal settlements. So, what the government can do is they can approach these neighborhoods, approach these blocks, and offer to redevelop them with public private partnerships, and then temporarily shift these people out of those regions. And once the redevelopment is done, they can be resettled back into those regions. So if you look at countries like Singapore, which used to have 90% population living in slums at one point, the government had to step in. They had to build large scale public housing, and then once re-regularization was done and people were rehabilitated back, they began to skill train them, and eventually these people were able to get good
See,
careers. They
see,
were
in India, the rehabilitation, like the purpose of rehabilitation is only this, and or like whatever planning you just mentioned is only this purpose to once a slum is completely removed, then a big buildings are being made up. But what in India, these things doesn't happen, because at the end here we have to see that the corruptions is getting involved here, like not a better way the politics gets involved. So how countries like India, not only in India, in the global south, you may be like took a reference of very developed countries, but in a global south there are countries who are underdeveloped. So how these countries can come up with a better government accountability? So without better government accountability, whatever you are proposing, that cannot be sustained, because these things will never happen. That this all these things will only happen in paper, but it will never happen in a practical ground. So, like, I will suggest you, yeah, to look into some of the reports of United Nations Urban Planning Commission, also some of the reports of the other United Nations branches and departments, where they have taken into consideration these kind of issues, how a better governance can be set up, or any model policy, if there is any. I am not aware of it. You should research upon it. Simply this legislative toolkit, it's not going to provide a equitable development per se, because these things will never happen when we looked into the consideration of countries like India, Pakistan, or any of the global south countries who are in a developing or underdeveloping stage.
So I understand that, but thing is, this toolkit and this paper is primarily focusing on regions which are approaching a transition phase. It's not primarily focusing on regions which are at the lower income bracket or which are not
Even
approaching a developed status yet.
in India, are you considering India in a transition phase or a lower income country? Definitely in
India is
transition.
India is a
Yes.
middle income country which is approaching a transitional phase. Some parts of India are approaching it first, earlier than the rest of the country.
So whether your reformative toolkit, what you are suggesting, are the government not coming up with this kind of policy? These are pre-existing in our constitution. That once a settlement has to be done, they have to provide with some compensation. Even the slums area has to be done. But what is the practical reality? Nothing is being done in that proper way. even though rules and regulations are well framed. So the first foremost problem is accountability. How we can increase the accountability of the government in a democratic setup? First thing is accountability, but here the accountability is nowhere mentioned. Like the government is coming up giving the project to the contractors, and then they are doing their own thing. Ultimately the people are like living behind it. So here the research, being a researcher, our purpose is to come up with a practical solution. This legislative solution is workable, but it is only workable up to the stage where countries are already developed, where every rules and regulations are being followed. You are understanding my concern, right? So that's yeah, that's where the policy has to be looked into. I will ask you to more write it in a reformative way and to look into some of the reports. So you should refer statistics data. Then only your paper should come up in a conclusion where you can suggest something. All right. Thank you for your presentation.
Thank you, sir.
Thank you, Shubheshavan. Now we have the last presenter of the day, Mr. Venkat Rao, researcher for the Center of Video Studies, for the presentation today.
Good evening,
Yes,
sir.
start.
Am I audible and visible? And the presentation visible, sir?
Yes, you can start with your presentation.
So, good evening, distinguished faculty, colleagues, and participants. So, as the things went uneven, I would like to specially mention the special thanks to Jasper sir and as well as like Yamini ma'am for the presentation of this paper. So, myself, Venkat Rao sir, today I will be presenting my paper title "From Vulnerability to Voice: Building an Equitable Climate Future for the Global South." So if you see, so in this presentation, I would like to cover the conceptual understanding or the conceptual foundation of the climate justice and analyze case studies from India, Nigeria, and Brazil. So there is a particular reason why I had taken like India, Brazil, and Nigeria. So, and in the following slides, I'll be explaining those, and also I will be highlighting about the key highlight challenges in implementation procedure, and as well as I would like to propose a legislative framework for the equitable climate transitions. So getting into the concept, so getting into the concept, I would like to start that. Sir, if you see the ultimate irony, the thing which we see that the ultimate irony is that the countries like Panama, Guyana, Laos, Cambodia, and many African continental countries, like the countries which have produced very least the greenhouse gas emissions, are now facing the greatest risk of the gas emissions. So how far is that the thing which is considered as an irony? And moving into that, like the climate risk or the climate injustice is like the initial risk. So there is an indirectly there is a whole supply chain which is which is considered as the which is considered as like disruptions in the economic supply chain or the whole supply chain, including trade or like in the food concerns or the poverty concerns or the economic status of the country. So if you see into that, the core tension lies in between the climate justice as well as the trade. And also following that, so the climate justice will be working on the three-dimensional principles, mainly the distributive justice, the procedural justice, as well as the recognition justice. So mainly coming into the distributive justice. So if we see into the distributive justice right from the start, from the year 1850, so whether it can be in the pros and cons as or the cumulative position. So the position of the developed countries, they have almost produced 79% of the greenhouse gas emissions like carbon dioxide and poisonous gases. So where ultimately the impact was being absorbed by the developing countries or the least developed countries. So this should be either strictly prohibited or there should be certain framework that need to be eradicated or it can be reduced. So ultimately the impact was produced by the developed countries, which was taken by the developing countries or least developed countries. So it should be the question that need to be solved. And also coming into the procedural justice, so if you see that while making the laws or any kind of frameworks, there has been always the developed countries in the upper hand position or the high position while determining the framework. So the marginalized countries like developed LDCs and developing countries, they haven't been concerned. They haven't been approached, or they have not consulted while making the frameworks. So ultimately, while the international law should be benefited, or like they should be helpful to overcome the problems in the whole of the scenario of the like developing countries. So I feel that there is a lag, that developing countries and the least developed countries are being neglected, and also they weren't heard properly. And coming into the recognition justice, so there's the climate risk initially. The climate justice risk is not only the only function, but if you see into the whole supply chain, there are like various concerns, like including food concern, poverty and economic disruptions, and also rights of the people or the marginalized communities. So, or if you see into the rights and everything, so there hasn't been given much priority to the other sectors like trade concerns and any other concerns. It should be a factor that need to be recognized, and also the recognition should be made, and also the concerns need to be addressed in the recognition justice. Coming into the global climate governance framework, so the climate justice mainly focuses on the three principles of the international framework, either in the UNFCCC and the Kyoto Protocol and the Paris Agreement. If you see into these agreements, so the whole common principle is like a common but differentiality responsibilities. I mean, like the recognizing that there should be like a united framework that need to be addressed with every country, whether in terms of battling the kind of negative aspects which was produced by the climate concerns, and as well as like the burden which was produced by the developed countries. So, and also, sir, like I would like to mention, so it's not always the moral values that drives the change. Initially, there need to be some kind of financial assistance that need to be achieved to overcome the problems. So, without any financial assistance, hardly the change can be seen. Hardly the change can be seen in any of the sector. So there has been like almost of $100 billion which was pledged by the developer countries to the developing countries, were not being distributed or not being allocated to the developing countries. It clearly shows the key concern why the developing countries and the least developed countries are facing the climate concerns. And so coming into the case studies like India, Nigeria and Brazil. So if we come into the aspect of India, so India pledged in the Paris Agreement that relating to that by 2070 we will be getting into the net zero of greenhouse gas emissions, and we will be focusing on the renewable electricity. So there is a concern while achieving in a greater sense, we always neglect in a way that the regional aspects or the lower aspects will be always disregarded and they'll not be considered. So India is one of the prime example that, so they had pledged about the 2070 goal of producing 50% of renewable energy. But if you see into that, even in the present scenario, India is solely relying on 78% of coal procedures or coal production for the production of the electricity. So there has been like concern when every investment was coming to the India, they were like merely mentioning the green energy transition, the green investment and everything which need to be in a transitional phase. But on ground reality, how far does it come into the reality, or on actual practice, how far it is being implemented? So coming into the Nigeria, we see that, so the whole of Nigeria is being dependent on the 80 fossil fuels like petroleum and gases and other oil exports. That is like 80% of the trade is being dependence on the oil exports. So mainly to overcome such kind of problems, like the Nigeria, they have established the Climate Change Act, which their main aim is to low carbon frameworks, and also like the dependency on the fossil fuels, and also there should be some regulations to the fossil fuel export and import nature. So coming into the Brazil aspect, so from the year 2002 to the 2024, as we all know that Brazil is considered as the lungs of the earth, which is having like Amazon forest and the whole of green scenario. We can say that like from the 2002 to 2024, there has been almost all 47% of deforestation in the Brazil region, which is
Participant, you can
considered.
move to solutions and recommendations. Your time is already up.
Sure, sir. So we can see that like these are all the concerns why it should be considered, and also there were like certain barriers to the climate justice implementation, like as I said, like it's not always the moral aspect that need to be changed, and also there should be some kind of financial assistance to overcome the problems. So if we see that almost all 2.4 trillion dollars was being annual funding gap by the 2030, which is being produced by the which need to be produced by the developed countries to the countries like least and LDCs and developing countries, so that they can overcome the burdens or the problems in the aspect of environmental sense. So I would like to provide the legislative aspects like inequitable climate transition framework. One is the equity-based responsibility and the just transition laws, and also climate finance legislation and the participatory governance. So everything is interconnected when CBDR need to be function properly, irrespective of the political transitions or the political aspects. It need to be given as much priority. Coming into the transition laws, there should be given for every sector there need to be some kind of protection, like coming into the employment sector or the food and trade, and every sector need to be prioritized in a key manner. As also climate finance legislation, irrespective of the financial funding gap, the finance assistance need to be processed thoroughly to overcome such kind of burdens. And also participatory governance, like every institutions, like vulnerable communities, marginalized communities, and also like developing and least developing, they need to be considered, their voices need to be considered in the transition framework of legal framework. So coming into the conclusion, policy recommendations and conclusions, so I would like to mainly highlight the accountability part and the finance assistance. So if we see that, so just a few minutes, just a single minute, sir, I would like to wrap up. So if we see into the accountability aspects, by taking into the Delhi's atmosphere or weather conditions, or how far the Minister of Environment and Climate Change was being considered in the aspects of the change in the climate conditions. So there shouldn't be any kind of lack in the communication or kind of resistance in the accountability aspects. Everyone needs to be work on their own aspects so that the concerns will be reduced. And also I would like to conclude that, so that we cannot afford climate justice tomorrow, sir. It must be delivered today, or inequality will be our legacy, sir. Thank you, sir.
Okay. As previously also, there are two or three participants who were presented on a similar climate justice in the climate this particular area. There, I had highlighted already, one of the major problem is double counting, like where the countries who has worked upon, and if they are having a reduced carbon emission, there are another country or the another company, they will come up with their credit, and they will say that the same things has been done just because of us, and also like a similar thing. So the on pen and paper, there are multiple things which happens on a government level. Like
Yes,
there
sir.
are countries who provide that they had reduced up to 20% carbon emission footprints, but on a practical ground reality, there are no one to testify it and to counter those government claims. So like these are the practical ground issues which requires a further more accountability of the government when they are coming up with this kind of issues. So my suggestions, I don't have any question for your paper, but my suggestion to for your research is you should look into these aspects. Like when a number is being doubled by the government or any agencies who are publishing a credible report that so and so country has come up with a negative carbon emission or minus 20% carbon emission. So what are the credibility of those reports? If those reports comes to comes to be a fake report, what are the consequences these people has to be followed? Because we see majorly and in the present generation, in the present time, many reports are being influenced by the superpowers.
Yes,
They
sir.
will say that they are the reasons of the carbon emission and the pollution, because as per the common sense, or as per many UN reports, but the superpowers of the developed countries contributes more carbon emission than the least developed countries. But
Yes, sir.
again,
Yes,
there
sir.
are also a number of reports which would be looking into there you will see a complete different aspect. So there are two
Yes, sir.
set of groups. So your research should look into this aspect and how we can come up with a government responsibility, also credibility. These are the major issues in order to tackle the climate justice system.
Sure, sir. Sir, and also I would like to say that so how far solely we can purely depend on the reports which was produced by whether WTO or like UN organizations or OECD and also UNTAD. So when such kind of if you see into the green investment or green energy sector, everyone is saying like we were into the green energy transition, but how far the actual thing is being produced on the ground reality, whether it kind of investment or whether it was installed in the agreemental aspect, or it needs to be in a like a post agreement aspect. So they need to at the whether in the speed ease of doing business, they need to mention about the so like annual reports whether from the established organization or the companies, they need to produce the whether it can be in a a negative scenario or a positive scenario. They can produce the data which was being produced, which was related to the green transition, so that it can be helpful to the how far the green transition is being implemented in a ground reality, sir.
Definitely, and for that, a detailed survey is required, and you will also get there a number of non-profit organizations working on this kind of segment, coming up with the ground reality surveys. There are also organizations going against the U.S. government in U.S., also in Canada. There are a number of multiple organizations, but here you
Yes,
have
sir.
to look into and refer those reports whenever you are tackling up with this, because it's all about the authority which you can claim whenever you are claiming something.
Yes,
So that's all for you. Thank you for your
sure,
presentation.
sir. Thank you, sir. Thank you for the opportunity, sir.
So that marks our end of our presentation. Thank you, Dipendra Daso, for being with us in this conference. And it has been a very pleasure for attending on this very eve of the World Intellectual Property Day and organizing Global South Dialogue on Law and Development 2026. Thank you, sir.
Okay, thank you, Mahesh, and thank you, team, who is involved in Global South Dialogue on Law and Development. So, at the end, since today is the World Intellectual Property Day, I'd like to wish happy World Intellectual Property Day to all. And also, we have to remember the cost of innovation is our awareness. So, if we are not aware enough, we cannot protect our innovation, we cannot protect our culture. So we have to be aware about our rights, we have to aware about our responsibilities. Then only we not only can protect ourselves, but also our surrounding, and also to give something to this society. With this note, thank you all of you. We expect
Thank you, sir.
more fruitful conversation in future. Thank you.
Thank you, sir.